So now we are going to learn about termination of contract or discharge of contract. So what means terminating a contract or termination of contract? It simply means legally or legitimately ending the agreement or a contract before all the parties have completed the terms and obligations of the contract. So sometimes a contract may just get terminated or the contract may be discharged, terminated before the terms are being met or before the purpose is met, or discharged when the purpose is already met. So termination, there are different conditions for termination. We will see how it goes. There is mostly 7 ways of termination of contract. Why termination of contract happens, we'll see, and how it is discharged in the slides. So a contract is said to be discharged or terminated when contractual obligations cease and the contract comes to an end. A contract may be terminated or discharged under the following circumstances. Discharge by performance, that is termination when the object or the purpose of the contract is fulfilled. 2. Discharge of contract if a substituted agreement is executed. 3. Termination upon completion of the term of contract or even discharge by lapse of time. 4. Termination under the operation of law, discharge by operation of law. 5. Termination in case the purpose is rendered infructuous, discharge by frustration or impossibility of performance, discharge by accord and satisfaction, termination by mutual agreement, and termination in case of breach of contract or discharge by a breach of contract. So the first thing is discharge by performance. Performance, that is completion of the terms of the contract or completion of the purpose of the contract. So discharge by performance occurs when the parties to the contract accomplish the purpose of the contract and fulfill their obligations as specified in the contract in accordance with or in consonance with the terms and conditions of the contract. Then, upon such an accomplishment or meeting of the purpose of the contract obviously comes to an end. Why? The purpose and the object is fulfilled. So, thereby, the contract is terminated or automatically terminates when the object or purpose of the contract is fulfilled. The question would arise in case of honoring consideration or making payment in case of part performance. Here, the rule of substantial performance would be used to determine whether the party who has substantially performed his part of contract would be entitled under quantum merit to a lesser contract price in case of a defective performance. So the principle of counterclaim or set off, as the case may be, may also come into play. That is, performance vis-a-vis defects would be examined here. For example, in an Australian case in Hoing versus Isaac, the services of the plaintiff were engaged for interior decoration of the defendant's bedroom, and a sum of £750 was to be paid as the work proceeds, and the balance on completion. The defendant refused to pay the balance of £350 since he was dissatisfied with the services and claimed that the furnishing was poor and required rectification. The cost of rectification amounted to $55. The court held the plaintiff had substantially performed the contract and the plaintiff was entitled to receive the balance after deducting £55. Next is discharge of contract if a substituted agreement is executed. In such a case, the terms of the contract or even the scope of the contract may be altered, and the parties may, with consensus addendum, that is, all the parties agree together to terminate the contract. Next is discharge upon completion of the term. A contract will automatically terminate upon fulfillment of the term of the contract, and a relevant clause to that effect will be reflected or added to in the contract. Next is termination under the operation of law or discharge by operation of law. Now, let us explain this with an example. Like, for example, a merger of two companies. So, by law, two companies are merged together and they become one. So, insolvency, bankruptcy of a party, or a new law that is promulgated, which may forbid any material term in the contract from being enforced. Next is discharge by frustration or impossibility of performance. Now, this occurs where the purpose in the contract is rendered infructuous or impossible to be performed. For example, A agrees to marry B and B dies before the marriage. So it's impossible. Or A decides to sell his best property, a house by the seashore, to B, and the house intended for sale is destroyed by tsunami. So these are some of the examples where there is a contract is impossible from being performed. So discharge by frustration or impossibility of performance. So there are two limitations to this doctrine of frustration. One, performance has not become entirely impossible. That is, mere hardship or inconvenience or material loss cannot be construed as impossibility to perform, leading to frustration of a contract. There's a case law in this. Performance has not become entirely impossible. Mere hardship, inconvenience, or material loss cannot be construed as the impossibility to perform, leading to frustration of a contract. Here uh, in Sakariloglo versus Noblithol. In this case, it's a German case. In this case, there was a contract for the sale of peanuts to be shipped from Sudan through the Suez Canal to Hamburg, Germany. So this canal, the Suez Canal, was closed for navigation, and the alternative route was around the Cape of Good Hope, which made the distance 4 times longer and more expensive. That means the route via Cape of Good Hope was, a longer route. But originally, they said that they are going to come via the Suez Canal. So the sellers failed to ship the peanuts, that is the goods, claiming that the closure of the canal had frustrated the contract. So they said that no, we will not send the peanuts or the goods because the Suez Canal is closed, and therefore it, the fact that the Suez Canal is closed, it has frustrated the contract or made it impossible to perform. Now let's see what the court holds here, or what the court decides. The court held the contract was not frustrated, or it was not impossible to be performed by the closure of Suez Canal. Transporting the goods via the Cape of Good Hope was more expensive, but not fundamentally distinct, as it was still possible to perform the contract without any damage to the peanuts. That was the product in question. So therefore, performance has not become entirely impossible. Mere hardship or inconvenience or material loss cannot be construed as the impossibility to perform, leading to frustration of the contract. So this is classic case which needs to be there in your answer books. That is Sakirologlo versus Noblithol, Germany, 1962, AC 93. Now, the court in this case held the contract was first thing it held that the contract was not frustrated by the closure of the Suez Canal. Transporting the goods via the Cape of Good Hope was more expensive, but not fundamentally distinct, as it was still possible to perform the contract without any damage to the peanuts. Two, if the frustrating event was anticipated and a provision to that extent is made in the contract, then it cannot be inferred as the frustration of the contract. And three, forcibility of the frustrating event. Next is self-induced frustration, that is on purpose. So English contract law case here is a case of Eugenia, which is also a ship, 1964 case, and Tram Tankers Corporation versus Sofrash. This will make the concept clear. In this case, the ship Eugenia was chartered for a trip from Genoa to India via the Black Sea. In the contract, there was a war clause which forbade the charterers, or which prohibited the charterers, or which prohibited the ship from entering a dangerous zone. The charterers entered the Suez Canal when it was such a zone and were trapped in the canal when the war broke out. The court held the contract was not frustrated because Eugenia was trapped in the canal. The charter company was at fault, and the charterers couldn't therefore rely on self induced frustration. So, discharge by accord and satisfaction. What is that? Where termination occurs by consensus addendum, that is, by mutual agreement of all the parties, due to whatever reason it might be, either that the terms are fulfilled or they do not intend to proceed with the contract, and come to a consensus on withdrawing, rescinding, or discharging the contract. Next is termination in case of breach of contract or discharge by a breach of contract. A contract may be terminated when a party to the contract commits a material breach, such as failure to perform a significant contractual obligation, the gravity of which act or omission would attract termination. The breach may constitute an irreparable breach. Further, any act which may be entirely illegal and in contravention of law may be yet another ground for termination. So, trespassing the rights of the other party, such as the terms of the confidentiality clause, when breached, would attract the right of the aggrieved party or whose contractual right is infringed to terminate the contract. So this would be termination in case of breach of contract. So next we would talk about breach of contract and the remedies that are available under the law of contract when a contract is breached. So only after this I'll be taking your attendance.